Hey, real quick, picture this. You're arrested for a crime you didn't commit. You're scared, you don't understand the charges, and the government has a full team of trained prosecutors, investigators, and legal staff building a case against you. And you're alone. That was the reality for most Americans until 1963. You had a constitutional right to a lawyer. It said so there in the 6th Amendment, but if you couldn't afford one, too bad, figure it out yourself.
How rude!
Today, we're covering the amendment that is supposed to level the playing field. The 6th Amendment gives you the right to a speedy trial, a public trial, an impartial trial, the right to know what you're being charged with, the right to confront witnesses against you, and the right to have a lawyer by your side. On paper, it's one of the most powerful protections in all of the Bill of Rights. But here's the question we're going to answer today. Is that protection real, or is it just words on a paper?
What is real?
Hey, real quick, if you're new here, I'm JP, a former Special Forces officer with 14 years of service, having deployed to 11 countries across 3 continents. I've worked alongside some of the best legal and military justice systems in the world, and some of the worst. I've seen what happens when a government can lock you up and throw away the key with zero accountability. The 6th Amendment is the answer to that. This channel exists to give you the tools to understand it, not to tell you what to think about it. Let's get into it. All right, let's read it. The 6th Amendment. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed by the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have an assistance of counsel for his defense. One sentence, 68 words, 6 distinct rights packed in tight. Let's count them. Speedy trial, public trial, impartial jury, notice of charges, confronting witnesses, and the right to counsel. Each one of those has its own case law, its own modern controversies, and its own ways it can go wrong. We're going to work through them all, but we're going to first start with a man who changed everything. All right, we're in Panama City, Florida, June 3rd, 1961. Sometime before dawn, someone breaks into the Bay Harbor pool room, smashes a cigarette machine, cracks open a jukebox, steals a little cash. Later that day, police arrested 51-year-old drifter named Clarence Earl Gideon. 8th grade education, a long sad story of crimes, and no money. Certainly not enough for a lawyer.
Help me, I'm poor.
No, listen.
In court, Gideon does something that takes real courage. He stands up and asks the judge to appoint him a lawyer. The judge says no.
How about no?
Florida law only required appointed counsel in death penalty cases. This was just burglary. So, Gideon stood trial alone. No legal training, no preparation, no one in his corner. He did the best he could. He cross-examined witnesses, he made arguments, but the jury convicted him and the judge sentenced him to 5 years. So Gideon went to prison, and in prison, he started reading law books. The more he read, the more convinced he became that what happened to him was wrong. The 6th Amendment said he had a right to counsel. So, from his cell at the Florida State Prison in Rayford, writing in pencil in prison stationery, he drafted a 5-page petition and mailed it to the United States Supreme Court. Now, the Supreme Court receives thousands of petitions every year. Most get denied without comment. But this one, this handwritten letter from a man who had never finished middle school, the court agreed to hear it. They assigned him one of the most prominent attorneys in Washington, Abe Fortas, who would later become Supreme Court Justice himself. On March 18, 1963, the Supreme Court ruled unanimously. All 9 justices, Justice Hugo Black, wrote the opinion, lawyers in criminal courts are not luxuries. They are necessities. Florida had violated Clarence Gideon's rights. Gideon got a new trial, this time with a lawyer. He was acquitted in less than an hour. And overnight, the ruling freed approximately 2,000 prisoners in Florida alone who had been convicted without counsel.
If you can't do the time, don't do the crime. Okay, time's up.
Gideon established that you have the right to a lawyer, but the story doesn't end there. A lawyer at a trial you've been waiting to have for 3 years? Is that really justice?
No, not really.
That's the question modern 6th Amendment is still trying to answer, and we'll get there. But first, let's look at where the 6th Amendment came from. You know, I love to go back in history, so let's do it. The founders knew exactly what a rigged justice system looked like. They'd lived under it. English courts could hold colonists in pretrial detention indefinitely, prosecute them in closed proceedings, use anonymous witnesses, and deny them any legal representation. The Star Chamber, England's secretive court in political prosecution, had only been abolished in 1641. The memory was still raw. Every single protection in the 6th Amendment was a direct response to something the founders had experienced or feared. The right to a speedy trial so you couldn't be imprisoned without end while waiting for a day in court. The right to a public trial so proceedings couldn't happen in secret. The right to confront witnesses so you couldn't be convicted by anonymous accusers. And the right to counsel, because even in 1791, the founders understood that without legal expertise, most people couldn't effectively defend themselves. What they couldn't have imagined, a country of 340 million people, thousands of courts, and a justice system so overwhelmed that many of those protections would exist more in theory than in practice. All right, let's get to the right to counsel. Gideon and its legacy. Gideon versus Wainwright was just the foundation. But one unanimous ruling didn't solve everything. The right to a lawyer and the right to an effective lawyer are different things. In Strickland versus Washington in 1984, the Supreme Court established the standard for what counts as an effective counsel. A lawyer's performance must reach an objective standard of reasonableness, and the deficiency must have affected the outcome. That's a high bar. Courts have upheld convictions in cases where defense attorneys slept through the testimony, showed up intoxicated,
What are you, drunk, Mr. Hurley?
Well, I had a few Chardonnays. What of it?
or failed to investigate basic evidence, ruling the representation, however bad, didn't quite fall below the threshold. The right to counsel problem has a modern dimension worth knowing. Today, roughly 80 to 90% of criminal defendants qualify for a public defender. They cannot afford their own attorney. A 2023 RAND Corporation study found that more than 9,000 public defenders across 33 states carry caseloads 3 times higher than the recommended maximums. That means, in many courts, your constitutionally guaranteed lawyer may have hundreds of other clients and be able to spend only a few hours on your case. Just last month, February 2026, Oregon's Supreme Court dismissed over 1,400 criminal cases because the state simply could not provide adequate counsel to defendants. Gideon said, "You have the right to a lawyer?" What Gideon didn't guarantee is that lawyer will have enough time to fight for you. All right, next, speedy trial. Barker versus Wingo and the backlog crisis. The right to a speedy trial sounds simple. It is anything but. In Barker versus Wingo in 1972, the Supreme Court addressed a case that had dragged on for over 5 years. Willie Barker had been waiting for trial while the government tried his co-defendant first, 16 times. The court set up a 4-factor balancing test to evaluate speedy trial claims: the length of the delay, the reason for the delay, whether the defendant had asserted the right, and how much the delay actually harmed the defendant. What the court deliberately did not do was set a specific time limit. The flexibility has real consequences. Today, more than 3/4 of judges and court professionals report experiencing hearing delays. In state after state, defendants sit in a pretrial detention, meaning they haven't been convicted of anything, for months and years waiting for their day in court. As of 2023, approximately 466,000 people were held in pretrial detention across the United States. Some have waited 8 months past speedy trial deadlines, some 2 years. During that time, they may lose jobs, housing, and the ability to gather evidence in their own defense. They are, in a very real sense, being punished before any verdict. And when courts finally rule those delays violated the 6th Amendment, the only remedy available is dismissal. The case gets thrown out, which means the defendant goes free regardless of guilt. So, judges understandably are reluctant to grant speedy trial dismissals. The system creates its own pressure to keep waiting. Third, impartial jury. Batson versus Kentucky. The right to an impartial jury has its own contested history. For most of American history, impartial had a racial asterisk. In Batson versus Kentucky, 1986, the Supreme Court ruled that prosecutors cannot use peremptory challenges, the ability to dismiss jurors without giving a reason, to exclude jurors specifically because of their race. Batson was a landmark ruling, but its enforcement has proven difficult. Prosecutors can offer race-neutral explanations that courts accept, even when the pattern is obvious.
I see what you did there. I know.
Researchers have documented persistent racial disparities in jury selection in courts across the country, decades after Batson. All right, next, right to confront witnesses, Crawford versus Washington. The Confrontation Clause got a significant reinterpretation in Crawford versus Washington in 2004. Michael Crawford was convicted partly based on a recording statement his wife gave to police. She didn't testify at trial. Justice Antonin Scalia, writing for the majority, ruled that testimonial statements, which are statements made in the context of a criminal investigation, cannot be used against the defendant unless the witness is available for cross-examination. It was a return to the founders' original meaning. You have the right to look your accuser in the eye and challenge their account. All right, next, right to counsel at sentencing. Villarreal versus Texas. One of the most recent 6th Amendment cases is worth flagging. In Villarreal versus Texas, argued before the Supreme Court in October 2025 and decided last month in 2026 of February, the question was whether the trial judge could prohibit a defendant and his attorney from discussing the defendant's ongoing testimony during an overnight recess. The court ruled the judges can restrict those discussions narrowly, specifically about the content of testimony still in progress, as long as the strategic consultation on other matters remains permitted. It's a reminder that even the boundaries of right to counsel are still being refined today. Let's put some numbers on this. The 6th Amendment's protections exist in a system under serious strain. Nationally, over 3/4 of judges and court professionals reported hearing delays in 2023. About 466,000 people were in pretrial detention as of the same year, held before trial, not after conviction. In 2023, RAND workload study found that public defenders in dozens of states are handling caseloads 3 times the recommended maximum. Only about 21% of state public defender officers have enough attorneys to adequately handle their caseloads, according to the Brennan Center for Justice. On the jury side, Batson versus Kentucky turned 40 in 2026. and racial disparities in jury selection remain documented in courts across the country. The O.J. Simpson civil trial, where he invoked the Fifth Amendment rather than testify, showed how civil and criminal proceedings interact in ways most people don't expect.
If OJ can get away with murder, why can't Sonny have his kid?
And one data point that surprises people, the Sixth Amendment's jury trial right only applies to offenses where imprisonment could exceed 6 months. Minor offenses below that threshold can be tried by a judge alone. Here's the honest picture. The Sixth Amendment contains some of the most important protections in the entire Constitution. The right to counsel transformed American criminal justice. The Confrontation Clause protects against secret accusations. The public trial requirement keeps the courts accountable to the community they serve. And yet, the right to counsel means something very different, depending on whether you can afford a private attorney or whether you get a public defender handling 3 times the caseload they should. The right to a speedy trial exists in a court system so backlogged that the guarantee is regularly violated. And the remedy is so drastic that judges are reluctant to apply it. The right to an impartial jury exists alongside documented patterns of racially skewed jury selection that persist 40 years after Batson. None of that makes the Sixth Amendment meaningless. It makes it a work in progress. Every constitutional right requires active enforcement, adequate resources, and a legal culture committed to taking it seriously. The Sixth Amendment tells us what a fair fight is. Whether you actually get one still depends on a lot of things that weren't written in the Constitution. That's not a political statement. It's a factual description of where the law is right now and why cases keep coming. All right, I hope you enjoyed this episode. Because next episode, we're moving to the Seventh Amendment, which most Americans have never heard of, but which affect one of the most common ways ordinary people interact with the legal system. Civil trials, jury rights outside of the criminal court, and a right that applies to lawsuits that most people assume are just handled by a judge. If you want to understand how the Bill of Rights shapes everyday life, not just dramatic criminal cases, the Seventh Amendment is the one you didn't know you needed. Be sure to like, share, follow, and subscribe so you don't miss out on episode 7. I'm JP, and I'll see you there.